And then 245, Stephanie here. $245, Stephanie. And then here. Okay, I got it. Yeah. Okay. And who do we have here?
This is Cedar Place versus Jacob Kawhi.
Okay. On the record, in the matter of Cedar Place Apartments versus Jacob Kawhi, file number 23-00445 LTE. Council appearance.
Good afternoon, Judge Christopher Asphalt, 53129 on behalf of the plaintiff.
Okay, you're Mr. Cry?
Yeah.
Today is the date that was set for a hearing on an eviction proceeding. Did you all meet already?
Yes, we did, Your Honor. Judge, this is essentially a first hearing. I spoke with Mr. Kwai and we were not able to come to an agreement. As such, I think I would request hopefully a brief adjournment to the court's next available hearing date. And we'll have to have a small hearing at that time.
Okay, Mr. Kwai, when I think you did set aside a default. Did you meet with legal services before? I need you to speak up because I can't hear you.
I say that now. I didn't hear it.
Okay, would you like to meet with legal services today? Okay, we'll get you on to Zoom and then you can do an intake with them to see if they can provide any representation to you. And then if you want to meet with our eviction diversion facilitator, he is here in the building. You can meet with him after your Zoom with legal services, okay?
So what am I going to legal services
To see if they can represent you?
or represent?
Correct.
That would sound good.
Okay. And then you can meet with Mr. Rosa to see if there are any resources that could help you avoid eviction, okay?
Yeah, so DHS paid 400 something for it.
They pay, DHS paid 400 or something?
Yeah.
When was that?
I don't know, but I received the letter.
Okay,
I received the letter from that.
okay, sounds good. So if you wanted to see if there were any additional resources, you could still meet with Mr. Rosa and give him some further information. Yes.
So that one is good for me to do it, but I want to clear that how this amount came about to go and look for the help, because I need to know exactly where this amount that I get.
Oh, okay, so you want to know where the amount is?
When I get that.
Okay, so he
I can
needs
go
a
and-
statement, ledger? Is that what he's asking for? Okay.
So let me know where it came from, and then after that one, I will go and look for help.
Okay,
Well, I
sounds
know
good.
exactly what I get charged, how I get.
I'm sure that he'll get that for you.
Mr. Kwai, you just ask your property manager.
Okay,
They'll
I'm
give you a
here.
copy of the ledger.
Yeah, I already got it. I got it.
Got it? Okay.
I got it. But I need to know exactly how much that I paid, how many months that I didn't pay. So compare that. So I need.
Okay, is this your client on this property here?
Yes,
Okay, so you can, she can get it from this young lady here?
yes.
Okay, so you go and see her and she can get it for you, okay?
It's not what she has down there. It's not. I want to go for it. Let me meet her. You go whatever.
You can meet with legal services. You're still probably gonna need a ledger if you're disputing the amount, okay?
The ledger that they have down there is not. It's not the right.
Well, what they have, if you dispute it, then you bring what you have, but they can only give you what they have. You can still dispute it, but you can't make them have a different ledger just because you dispute it. You have to show us evidence of why what they have is not accurate, okay? Whether that means that they're charging you the wrong rent or you paid more, you'll bring that evidence at the time of a hearing. Okay,
They are the people that married, they have everything.
okay,
But what is in their lease, because what I signed, the lease that I signed, I need the lease that I signed.
you need the lease that you signed. So you
that
don't
prove
believe that
how
the
much
lease that
I
they
paid.
have is the one that you signed?
So I might show that how much that I paid, and how many months that I missed. Not
Okay,
paid.
okay,
So and
sounds
from
good.
there, so I have to add up the amount that needed, and then I will go and look for help if I didn't pay.
Okay, sounds good. So what we'll do is we'll get you on with legal services when they're available and they can do an intake for you, okay?
All right.
Okay. And we'll get you a hearing date. July 26th at 2:30. July 26th at 2:30. Does that work for you, Mr. Asphalt?
It does, Your Honor.
Okay. Do you have any questions today, sir?
No.
Okay. Any additional matters for the record?
No, Judge.
Okay, we'll get your notice to appear and you'll be all set on this for today, okay?
Thank you, Judge. Have a good day.
Thank you, same to you.
So I will stay.
I'll meet you.
If you have a seat right out there, we'll get you the notice.
Okay, thank you.
Thank you.
If you want to talk to me later.
Yes, please. Okay. Do we see Ashley Green or Gary Vines? No?
Yes, they're all, Miss Gable was speaking with them. So she says it might have a possibility. She's trying to judge for it. So she said
Who does Miss Gable represent? I don't think I have her appearance.
E3
Oh,
Investment.
she does. I see her. Okay, sounds good. They are present in
Yeah, they're in the
person?
hallway. Yep.
Okay, sounds good.
Right.
Thank you. Mr. Dua, how are you? You met with Ms. Hernandez already?
I didn't.
He's on Zoom,
She's on Zoom?
correct?
I'd be happy to jump in
Okay, very
and talk
good.
to her.
Ms. Hernandez, the attorney for your landlord is gonna log in to meet with you, okay?
Yes, ma'am.
Okay. And then Ms. Whitty is here. I don't see anyone here for Keith Seelhoff yet. I do see Tanya Snorden, but she has not started her audio. But Ms. Till, my understanding is that you filed an appearance.
That is correct, Your Honor.
Okay, did you want to speak with Ms. Whitty today?
Yes, if I could, and then, or, yes, if I could.
Okay, let me put you all in a breakout room.
And then if Miss Snorden does get her audio started, could she be placed in that breakout room as well?
Absolutely.
Thank you. Does get her audio started, could she be placed in that breakout room as well?
Am I sharing screen? I am. Okay, can you hear me, ma'am?
I can hear you now.
Okay, I'm gonna place you in a private meeting room with your attorney, okay?
Okay.
I'm gonna put that iPad into a private meeting room, and then when Ms. Till is available, I'll add her to that room, okay?
Okay, thank you, Judge. Just hold on.
Thank you. Hernandez in room 3. Mr. Dewar, I'm gonna add you to room 3.
Let's see. Very nice. Your Honor, is there anyone from Sim Top Management on?
No.
Okay, thank you.
No problem. Tenants at the meter.
Yeah.
Hello,
It's a new one for me, but
not me.
so I have one, 270.
Crazy.
It's the adjournment for the bench trial.
Okay, well, I guess
Maybe the meter was far.
Yeah.
I'll go back. I'm gonna try one more time. Okay. I lost you guys. You guys wanna go one more time?
Are you all set in the breakout room?
Yes, sir.
Mm-mm. Okay, Ms. Hernandez, can you hear us?
Yes. Yes.
Okay, give me just a minute. on the record in the matter of Monopoly Apartments versus Christina Hernandez, file number 23-00668 LT, council appearance.
Thank you. Sam Dua here on behalf of plaintiff.
Then Ms. Hernandez is present via Zoom. Today was the date and the time that was set for a hearing for non-payment of rent. The parties did meet privately. Did you come to an agreement?
We did, Your Honor. Your Honor, I have in front of me a proposed consent judgment that states that the rent to retain possession amount is $1,875. The costs in the matter are $165.82, totaling $2,040.82 to be paid on or before July 7th, 2023, to prevent order of eviction from issuing. I have met with the defendant in the breakout room. I advised her of her rights of the waiver of the trial, the waiver of an attorney, which she has already had an adjournment to seek counsel, and her rights to rescind this consent judgment with your permission after writing in 3 days. I've also requested from the defendant permission to sign on her behalf, and I have done so with her permission, if I may approach.
You may.
Thank you.
And Ms. Hernandez, you heard everything indicated on the record by Mr. Dua?
Yes,
Okay, so I do have here a consent judgment. You're willing to waive your right to have a trial on this matter?
yes, ma'am.
You're willing to waive your right to be represented by counsel in this matter?
Yes, ma'am.
And you're entering into consent judgment to pay the amount of $1,875 plus $165.82 in cost, for a total of $2,040.82 on or before July 7th, 2023, or you're going to vacate the property by that date. That's correct?
Yes, ma'am.
Anybody threatening you to get you to waive your rights and enter in consent judgment?
No, no, ma'am.
Has there been any promises made to you in exchange for you waiving your rights?
No, ma'am.
You have 3 business days from today's date to return to the court. If when you leave here, you realize you misunderstood any of the rights that you just waived in order to enter into this agreement, you can request to have this judgment set aside, okay?
Okay,
You've given Mr. Dua permission to sign your name to this document, correct?
yes.
Okay, do you have any questions for the court?
No.
Any additional matters for the record, counsel?
Nothing, Your Honor. Thank you.
Okay, you're all set, Ms. Hernandez. Thank you.
I thank you. Bye.
No problem. Is it the, oh, you have one at 2:45.
I do. I know it's a little bit early, Your Honor, but are either of those parties in the Zoom?
Not at this time.
Okay, thank you.
You ready?
Yeah, we're gonna, I guess we're going to proceed with going before the court today.
Oh, okay. On the record in the matter of E3 Investments LLC versus Gary Vines and Ashley Green, file number 23-00803 LT, appearance for the record.
Catherine Gable on P81555 on behalf of plaintiff.
Can you state your name for the record, please?
Gary Bonds.
And your name?
Ashley Green.
Okay, today was the date and the time that was set for a hearing on non-payment of rent. The parties met and they were unable to enter into a agreement or consent judgment or anything at this time. Is that correct?
Yes, Your Honor, as I understand it, the plaintiffs wanted, or excuse me, defendants wanted a minute to ask you a couple of questions before proceeding.
Absolutely.
I just wish that I could get counsel here, because I really need somebody here to represent me.
Oh, you had an opportunity to do that. We were back here in May. We advised you of your rights at the time. And you also had the right to represent counsel. You had the right to meet with legal services. I wrote here a note, declined resources. You declined to meet with them at that time. We're proceeding today. Any other questions? Did you want to meet with them privately now?
I've never been through this before. I don't
I
know.
recognize you probably never been through this. That's why we had a pretrial. The pretrial stage was implemented for the purposes of advising you all for your rights. We have resources here. Legal services was here. We had an eviction diversion facilitator here. I asked you if you wanted to meet with them. You told me no. I can't force you to take help. Now, here we are, 2 months later almost, and it's a hearing date. And now you want to stop to meet with someone. You're living in someone's property. They say you owe them some money.
I'm out now. I just don't agree with the amount they're saying.
Oh, you vacated the property?
Yes, ma'am.
You turned the keys over
Yes, ma'am.
and you left it in room sub condition?
Yes, the way I received it.
Okay, so you're disputing the amount of past due rent?
Yes, ma'am.
Okay, you can proceed with your claim.
Thank you.
Fine, they'll submit any defense they have.
Thank you, Your Honor. At this time, plaintiff calls Eric Romano to the stand.
You can testify from there. Just make sure the mic can pick you up. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. I want you to state your first and last name and spell both of them.
Eric Romano, ERICROMANO.
Thank you. You can proceed, counsel.
Mr. Romano, what is your relationship to E3 Investments LLC?
I'm the sole owner of E3 Investments.
Okay, and as a sole owner of E3 Investments, do you manage and operate certain rental properties?
Yes,
Okay, Mr. Romano, do you manage and operate a rental property located at 1238 Cleveland Street in Lansing?
yes, I do.
Okay. And in management of that Cleveland Street property, did you enter into a lease with Ashley Green and then Mr. Gary Adam Ray Vines?
Yes, I did.
Okay. And do you recall the date of that lease?
It was late December 2022. And the lease date start date was December 25th, 2022.
Thank you, Mr. Romano. At this time, Your Honor, I would ask to move to admit the Michigan Residential Lease Agreement, which is attached to the complaint as Exhibit 1.
Have they seen that?
Yes, ma'am.
Okay, no objection to that exhibit as your lease? That's no objection, correct?
I'm just wondering about the way the date is at the top, and then you go down a little bit and it's scratched out, and then another date's wrote.
Do you have a copy of your lease with you?
No, ma'am.
Oh, okay. You said that the date at the top here, which says December 18th, 2022, and then it's scratched out where?
You go about halfway down on that page.
On that same page?
Yes, ma'am. It says the 25th or something right there.
It says rent to be paid. The rent will be due on the 25th of each date. Oh, you mean down here where it says 12/25/22?
Yes, ma'am.
It says that you would be permitted to occupy on a month-to-month as of 12/25/2022. You're disputing that as the date, or Are you alleging that this was changed? I'm not following what your concern was.
I didn't move in until the first.
Of what month?
There had to be some things cleaned before we could move in.
Okay, when did you sign your lease? This says you signed it on this. Well, this is not a signed copy. Is there a signed copy? I should.
Is that what they did?
Mhm.
So it appears at the bottom of the last page, that's where they signed it, Your Honor. And they provided that information, that is the signature on the lease.
Okay, so at the bottom where it says full name, date of birth, social
Yes,
security number,
yep.
that was indication that they had signed it?
That's their handwriting, correct, Eric?
Mhm.
Yeah, so that's not my findings. That was their signature on the lease.
Those are your signatures?
I think so.
You can-
May I approach?
Yeah. Here.
That's your signature either. That's not my signature.
Who wrote that there? Is
That's
that your
not Ashley's
handwriting?
signature either.
Is that your handwriting?
Nope.
Okay,
That's definitely not mine.
okay, well, the exhibit will be admitted, but they object as to the authenticity of the
We had
signature.
issues too with the last of our security deposit. He wouldn't let us move in until then. So we had to wait a week before we could even. move
Because
in.
the house was.
You're gonna have an opportunity to tell your whole story, so I'll just note here that you're disputing your signatures on this, okay?
Yes, ma'am.
Okay, you can proceed, counsel.
Yeah, am I-
You can have it back. It's the same copy that's in the
Yeah, thank you. Your Honor.
file.
Okay, Mr. Romano, back to you.
Mhm.
This is the lease that you presented to the defendants in this case, correct?
Yes,
Okay, and according to that lease, what is the amount owed for rent?
$1,200 a month
When is the rent due?
on the 25th of each month.
Okay, if rent is not paid on time, are late fees charged?
Yes.
What is the late fee amount?
$50.
Okay, in addition to rent, are the defendants required to pay any additional things like utilities?
Yes.
Okay. Mr. Romano, when was the last time you received a rent payment from the defendants?
The only rent payment I received was for the first month's rent. So that was,
Would that be for the period December 25 through January 25?
right,
He says the only rent he received? Okay.
And so, Mr. Romano, did you receive a rent payment for January 25 through February 25?
no,
Did you receive a rent payment for February 25 through March 25?
no,
Did you receive a payment for March 25 through April 25?
no,
And have you received a payment from April 25 through May 25?
no,
Okay, Mr. Romano, did you charge the late fees according to the lease?
yes,
Okay, and that's $50 a month?
right,
And based on my calculations, is that for 4 months?
yes,
Okay, so in addition to the $1,200 for rent, they also owe $50 in late fees for 4 months?
yes,
Okay. And did you ever have to pay utilities while the tenants or the defendants occupied the premises?
yes.
Okay, and how much did you pay, if you recall?
It was roughly $220.
Okay, roughly? I'm gonna need you to testify as to the exact amount if you know it.
If you're asking me right now, I'll say 219.
Okay, so 219. And who did you pay that to?
Consumer, I'm sorry, not consumers, Board of Water and Light.
Okay. And at any time during the tenancy, did either defendant contact you and complain about the condition of the premises?
No,
And in your opinion, was the premises kept in habitable condition at all times during their tenancy?
was it kept habitable?
To your knowledge?
To my knowledge, it was habitable when they moved in. It was clean, it was remodeled, it was painted, carpets were fresh. Never received any complaints about it being otherwise.
Okay, and up to the date of today's hearing, have you received any complaints, any text messages, phone calls, or anything, emails from the tenants claiming that there's any issues with habitability in the premises?
No.
Okay. To your knowledge, Mr. Romano, are the defendants over the age of 18?
Yes.
Okay. And Mr. Romano, in addition to the rent that I calculate as $5,000 through May 25, the late fees that I calculate at $200, the utilities at $219. Is there anything else that you are owed under the lease?
I had to pay someone $50 to mow the lawn.
Okay, and are the defendants required to mow the lawn under the lease?
Yes, under the terms of the lease, they are required to mow the lawn and shovel the snow.
Okay. And Mr. Romano, just for clarification, are you the only individual that would ever receive rent payments on this property?
Yes.
Okay, and you're the only individual with knowledge as to what payments were received, correct?
Yes.
And what, well, besides council, of course, and what payments were due for, mowing and utilities and things like that, correct?
Yes.
Okay, no further questions, Ryan.
Did you want to cross-examine him? Ask him any questions? You can cross-examine him or ask him any questions.
Oh, yes, sir. So about the grass being cut, so you're saying you paid a guy who's employed at my work. He showed up at my house and said, "Oh, dang, I see that I can't cut the grass because it's already cut." I was like, "Yes, sir."
To object, is there a question?
What's the question?
So he's saying that he paid somebody.
You can ask him a question right now if you want to give testimony. That means you want to tell us your side of what happened. You have to do that when you're under oath.
Oh.
Right now, you're just asking him questions.
So you are saying that you paid somebody to cut my lawn?
Well, I'm telling you that I requested that Roy cut your lawn. And I can show you his text message back to me when I asked him, "Did you cut the lawn?"
Okay. And how did you pay Roy?
Roy's another tenant of mine, so we just take it off his rent.
Okay.
And he hasn't paid the rent yet. He's supposed to pay it this Friday.
Oh. Okay, so when was he supposed to mow the lawn?
Let me see.
This was recent?
Yes.
Okay. You can ask your next question.
And then it was said that the house was inhabitable. Doesn't it say on the lease, there's a lot of notes on there about, you said it was remodeled before we moved in, but there's a lot of things on the lease about stuff that wasn't done, I believe, right, Mr. Romano? Like the carpet was shagged, it says clearly on the lease, some issues with the house. If, Mr. Romano, if you moved in a house, wouldn't you expect it being remodeled? Wouldn't you expect it not to have all those issues with it?
Can you ask him specifically what the issues were? Because I only see where it says the carpet was shaggy. and
The
worn on
strip was
steps.
torn off of the strip was torn off of the sink.
Oh, is
sink
that what it
was
says?
leaking.
I thought it says on steps and bathroom, entrance area, sink, and countertop edging came on. I don't see what you're talking about.
She said that it was a new carpeting that was put in.
Okay. You can ask your next question. That one didn't really seem like a question.
Oh, if new carpet was put in, wouldn't you expect the carpet to be in good shape when the tenants moved in?
That's the question. I never said the new carpet was put in.
You said earlier that the house was, that you remodeled the house before we moved in,
The kitchen was brand
and it
new.
was all painted.
He said fresh carpets, not
Fresh
new.
carpets was brand new.
He didn't say brand new. He said fresh.
Fresh
Definitely not
carpets. I guess. I'll
You can
wait.
ask him what fresh carpets mean though.
Yeah, what does fresh carpets mean to you?
Carpet that smells nice, looks reasonably well. Carpet that was freshly, which it was.
And Mr. Romano, wouldn't you say that the upstairs, the whole upstairs of the house doesn't have any carpet in it? It's subfloor.
I would say that the upstairs is the way it was when you saw it, when you wanted to lease the house. So
Mr. Romano,
so you went upstairs, you had ample opportunity to inspect the house. Yes, it's got bare wood floors upstairs that are painted. You deemed that acceptable, and you signed the lease and moved in under your own will and accord. And that's all I've got to say.
yes, sir. And Mr. Romano, wouldn't you say that when we signed the lease, I couldn't move in because you had to have somebody come out and re-clean the floors? When we signed the lease, I couldn't move in that day because you had to have your lady come and clean the floors upstairs because I said that it didn't look right.
No, that's not true. It's not true.
There wasn't a white sheen over the floor. You didn't have to have a lady come in and clean the upstairs before we could move in.
I had a cleaning lady clean the house, and I had a carpet cleaner come in and professionally steam clean the carpets.
After we signed the lease.
I don't remember when that is.
That's all, I guess, Your Honor.
Okay. Any questions from you? Any redirect?
Sure. Mr. Romano, when you said that you testified that you did have the carpets clean, was that just in preparation to make sure that the premises was in good, clean condition when they moved in?
Yes.
Okay, Mr. Romano, and he testified that when he signed the lease, he couldn't move in. That was on December 18th. What was the date of occupancy on the lease?
December 25th.
And Mr. Romano, was that to give you time to have your house cleaner go into that premise to make sure that the house was clean and ready for them to move in?
I'm gonna say I don't honestly remember that, the exact day that she went in there, but obviously her purpose for going in there and cleaning was to make sure everything was spick and span and ready to go.
And Mr. Romano, has the premises been inspected by the rental code enforcement department in the city of Lansing?
Yes.
Has it passed all of its inspections?
Oh, yeah.
Okay. And is this the first time that Mr. Vines has ever mentioned an issue with the upstairs flooring?
Yes.
Okay, no further questions.
Okay, thank you. Any other witnesses?
No, Your Honor.
Okay. Are you looking to give testimony today, which means to tell your side of what happened?
Yes, ma'am.
Okay. Both of you gonna do that?
I think I can handle it.
Okay. Are you looking up evidence on your
Yeah, I
phone?
was trying to find pictures.
Okay. I'm gonna put you under oath. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can tell me your side of the story.
So, right around Christmas, we went and signed the lease on everything. And I needed a house pretty bad, so Mr. Romano was nice enough to let us move in. We didn't get to move in the house when it was set. So how I learned about the house was from the guy that he's talking about at my work. It was through a mutual friend at work. I was told that there was a property available for $800 a month. So I went and met Mr. Romano because I said I wanted the house. I waited a couple of weeks to get in the house. Once I met Mr. Romano on the house, there was work still being done on the house, so I couldn't move in till a later day. I've never been through any of this before, you know, so I just took that it was a good boy, you know. I guess you live and you learn on things like this, you know, but I just thought that because it was a mutual friend at work, that everything was gonna be okay. I let Mr. Romano know about the leaking sink and stuff like that. That's what we're trying to look up. The only thing that I done wrong is I do agree, I should have moved out a little bit earlier, but I would have been homeless, you know, and I've got a family that I'm trying to take care of. If Mr. Romano would have communicated with me better than what he did, I would have told him everything that was going on. I mean that from the bottom of my heart, but there was no communication at all with this. That's why everything was, you know, sure, somebody knocked on the door and gave me a summons to court and all that. But before we lead up to everything, he says he never communicated with me. I communicated with him one day. He called and he asked me, he said, is it too much rent? Did you bite off too much? And I was like, you know, it is a little steep, the $1,200, you know. We carried on a conversation. I was at my work. I want to say I was in an office at work, but I pushed everything back so far, I can't even bring proof of stuff like that, you know? But there's no way. And about the $50 of the grass, I got a letter from the city in my mailbox that said they do not participate in no mow May. I mowed the lawn that day. That day I mowed the lawn, you know, that the very day that I opened the letter, you know. And it just seems like when we got here, you know, like me and Ashley both. I mean, I'm an honest person. I want to pay him back what I owe him. But just the smoke talk and everything, I guess that's just the way courts are. But just the way we was talked to in the hallway and everything, we threw up our guard, you know, because I feel like that he's trying to take advantage of me and get every penny he can out of me. The door that he says was busted, that they said, it's on Cleveland Street in Lansing. The door would never lock proper. It's only one lock on the bottom of the door. There's not a deadbolt or nothing on that door. So I had to take a 2x4 and put to wedge the door closed because it would never close the whole time we lived there. If he would have called and told me, I would have told him to go through the other door instead of trying to force that door open. That's the only thing I can think of why the door is busted, if it even is busted.
Wait, who busted the door?
Mr. Romano told me in the hallway that the front door was busted, that I had no recollection of.
The front door, are you still in this property?
No, we moved. I sent a message on May 31st and I didn't get any answer for a couple of
You
days.
sent a message on May 31st that you vacated the property?
That I was moving out and I had another place to live.
Okay, when did you vacate?
Like May 3rd. There's a couple of things that I didn't, there's a couple of things that I couldn't get out. There's like a bed and a couple other things.
So you still have personal items in the property?
There's a bed, yes, ma'am.
Okay.
But I was willing to let that go if he was gonna take the keys back. He told me to leave the keys.
Okay, what day did he tell you to leave the keys?
It was on the exact day, I believe May. I texted him on May 31st. I didn't get a response back until I text on May 31st.
What did you text?
I text him and he texted me back on June the 1st. You can leave the keys in the lockbox.
What did you text him on the 31st?
I said, Mr. Romano, we are moving the last stuff out today, hoping to do the walkthrough in the next couple of days. We are cleaning the house back to where it was given to us. I'm sure people have told you that before, but I'm not that way. Can you meet one day this week to turn keys back over and I will give you my new address? Best, Gary Vines. I can let you know by 6 p.m. the exact day. We just had the bedroom left and a little more cleanup.
Okay, and his response was just leave the keys?
Just leave the keys in the lockbox.
Okay, sounds good. Okay, and then as to the claim that you owe for 4 months rent totaling $5,000. You dispute that?
Oh, ma'am,
You don't dispute that you owe that?
I don't dispute that, I do owe him that.
Okay, what
But I
about,
also paid, like I said, I also paid a $1,200 security deposit when I moved in.
okay,
And
so
their,
you think that, and that should be,
their answer to me is the door was busted. The
Okay.
door was busted. So, I'm not gonna get the security deposit back if they're already trying that move.
okay, well. They've not made any claim here about the door being busted. We just heard his testimony. I didn't hear anything about that. Heard about that from you. 250, I'm sorry, 219 for utilities. Why did he have to pay utilities for them?
Do you want me to respond?
Yeah, he's gonna inquire.
Mr. Romano, why did you have to pay the utilities for the defendants?
When we signed the lease, it was stipulated that the tenant was responsible for all utilities as well as mowing the lawn and shoveling the snow. And when I began receiving bills at my house, I paid them.
Okay.
And
Yeah, a bill for what? And do you have a copy of the bill that you paid? The utilities were in your name?
The utilities when we moved in was in Mr. Romano's name.
Okay,
We
so,
was told to put them in our name. And with board, water and light, they do a process where when we tried to put it in our name, they said that we was not applicable to put it in our name. They denied us. So then I had to research and get a family member to put it in our name because our credit wasn't good enough to put it in our name. But I never intended, all the utilities was on when I moved into the house, So, and Mr. Romano knew that when I moved in, but it was kind of an agreement too, when we signed the lease that we was gonna get it put in our name, which I did.
okay, but it just took you some time to put it in your name?
Yes, ma'am.
So you're not disputing that he had to pay the utilities originally?
No, I'm disputing that.
The amount?
Yes, I got a
Okay,
letter.
I'm pretty sure he can pull it up though. If
Uh-huh.
he shows you to it, will you still dispute? Well, why don't you show him what it was? I don't need to see it. He can see it.
Let me hang on, let me make sure that it's clean and straight. Yeah. Cleveland Street. 4.45
this one.
I was trying to figure out, Your Honor, because I got one email that said $79. And I think she was trying to explain that to me, but I just didn't understand how she was explaining it to me, how it went up. Because the first letter we got, it said 79 for utilities, and then the next letter we got, it said 2 something.
I can clarify, Your Honor. We filed this lawsuit on March 9th. They were served on April 18th. They had not paid utilities. And so obviously, when we filed our lawsuit, utilities were owed as, I think it was somewhere around $70. Another month went by that they did not pay utilities. So obviously that number is going to change. I amended my complaint on June 12th. And that's where we included the $217 for utilities, because obviously that number would change until they put the utilities in their name. I haven't heard any testimony as to when they actually did that. The only testimony I've heard is that they did not do that when they moved in.
Correct. It doesn't sound like he disputes that they may owe. I think he just probably needs to see evidence of where or why he owes that amount.
Yes, and that's fair.
And then when I asked, they kind of got smug with me, so it was like,
And then you're disputing the $50 for mowing the lawn.
Yes, ma'am, absolutely.
Okay. If you can resolve the utility.
We'll waive it.
Okay, they're gonna waive the utilities, okay? So you're not disputing the $5,000, so that's gonna be ordered. You're okay with that?
Well, what about my deposit?
Okay, what about his deposit?
Because they're not gonna play fair. Oh, sorry, I'm sorry.
So in addition to the $5,000, I would ask the court prorate rent from May 25 through the date that they have vacated, even though they have not informed the court what that date is.
Well, they did. It said it was May 31st. He read the text message that he sent to your client and asked for a walkthrough. Your client said, just leave the key.
That text message was incomplete. So there was more messages, and I would like to ask if he could
Please.
testify as to that. Mr. Romano,
Yes,
did you go to the premises on June 7th?
I did.
Okay, Mr. Romano, and were there personal belongings in the premises at that time?
Yes.
Was there food in the fridge?
Yes, there was.
Was there a bedroom, bedroom furniture?
2 bedrooms.
Okay, and was there what appeared to be a queen size bed in one of the bedrooms?
Queen or, you know,
Okay, and then a
Double.
twin size
and
bed?
then a twin.
Okay, and various, like animal cages and things like that in the backyard?
Yes.
Okay,
Animal cages?
yeah.
You all leave animal cages?
They was left there when we moved in. There was we moved in December, Your Honor, where there was some weather. I mean, you know, and when the snow melted, it was a mess outside the house.
So you're saying those weren't your cages?
No, ma'am.
Okay. You left bedroom furniture?
I did leave a twin bed. Yes, ma'am.
Okay, and a queen?
No, ma'am. Not at all.
Okay. What about food in the refrigerator?
No, ma'am. I took that out.
Okay. Oh, you said the text messages weren't complete.
Yeah, and we have photo evidence of the walkthrough on June 7th, which are time stamped.
Thank you. But here's the issue with the June 7th timestamp. He messaged him on the 31st and asked for a walkthrough. He didn't grant it to him.
He actually, Your Honor,
That's what I need to see,
and I'm not
that
trying,
he granted it
Can I
to him.
submit
I'm not
mine
trying
to
to be,
Well, if they have the whole conversation, that's fine. If he has where he was gonna be willing to give you a walkthrough and then you prohibited that, that's different. But your text message that you read, you asked for a walkthrough and you said the response was,
Put it.
Just leave the-
That was all he said.
so I would reiterate that Gary said, I can let you know by 6 PM, the exact date. We have just have the bedroom left and a little bit more cleanup. 7:57 AM the next day, you can leave the keys in the lockbox. He responds, all right, I will wrap it up this evening after I get out of work to clean fridge and mop, but I will text you when all done. I still have that key, that real estate key fob that was there, and I will place keys inside there. But I will text you this evening when all done. He did not hear from him. He goes there on June 7th. There's still items in the house. On June 8th, Eric texts him again and says, are you done moving your stuff out of the house? No response.
okay, can I see the pictures too? You didn't respond after he texted you back.
Ma'am,
Did you respond after he texted you back?
that when he said you can leave the keys in the lockbox, I responded, but there wasn't, I was ignored. I mean, nothing else came back. What do you say? that when
Well,
they-
she just read the text message where he said, did you get all your stuff out? Did you not respond to that?
did I get on? I guess I'm confused now. Hang on.
Okay, let me go through these pictures first. There's a cage, or what is this?
That's the backyard.
Okay, and what am I looking at?
June
though?
7th, I think it's a 650 something at the top.
And you're saying that this was
That's
property that they left?
on June 7th, yep.
Was that a grill or something?
A barbecue, I think.
Barbecue, did you leave your grill?
Yes, ma'am, I think I did. The grill is mine.
Okay,
It's
there's,
covered up, the Weber grill.
looks like there's some
But the-
cages,
Those are not mine.
Plant.
Those is in the backyard.
a box from some bubbly, some other stuff on the porch, some plants, a broom. Box that says kitchen, that looks like it has some kind of caging and a lawnmower, but you saying that's not your mower?
No, ma'am.
What about this cooler and all these bottles? Whose is that?
And then
No, what my question was, who's all these bottles?
those,
Pop bottles.
those weren't mine.
Oh, they were there when you moved there?
No, ma'am, they wasn't mine though. Yeah, I would.
So this ginger beer stuff on the porch wasn't yours?
So whenever can I come forward to see it?
No, you may not. I wanted, there's bottles on and that look like they were collected. Those aren't yours.
I don't think so, no, ma'am.
Oh, okay. Okay, it's a lot of food in the
My
fridge.
fiance's saying that we got a letter saying that we don't have to be out till the 9th.
Yeah, There's a lot of food in the refrigerator.
Yeah, that was before the date we had to be out.
This picture was taken June 7th at 6:34
And it
PM.
was June 9th that we were supposed to be out. We were
Okay,
still
well,
in the
then-
process of moving everything.
Oh, okay, so then you can get the rent until June 9th.
Okay, thank you. May I approach you?
You may.
Oh, okay, sorry.
Okay, so they're not disputing rent, owed of $5,000, and then, prorated rent up till June 9th will be ordered. As to the security deposit, obviously some cleaning needs to be done. I don't know that that's $1,200 worth of cleaning.
Yeah, we had all intentions to do the security deposit disposition letter. And of course, any amount that's retained for non-payment for rent would be credited to the judgment. I explained that. And then I also explained that they could also respond to that letter and we could come back here and discuss anything that they dispute as to the security deposit.
Okay, you understand that?
Not.
They're gonna send you a letter about your security deposit. And then that letter will also disclose what they believe that needs to be deducted from that, because they have to now clean what you left in there. And he's gotta pay to haul this bed away. I don't think you want to keep the bed, Mr. Romano? I don't think he wants to keep that stuff. So he's gotta now pay to get rid of it. And to have it picked up. And then the walkthrough, any damage that was done to the property, you can expect to hear about that in the letter.
And
You'll
then-
have an opportunity to respond to that letter, though.
And then how does if he gets, say somebody from work that does all his work for him, and then he tries to charge me $800 for hauling the bed away, but he takes $50, can I come to court and make sure that that's held?
Well, yeah, you're probably gonna have to bring that person to prove that he didn't pay the $800. You can't just, but you have the right to respond and dispute what is stated in the letter. But they're gonna send you that letter. They have not done that yet, okay? You have any questions about that right now?
No, ma'am.
Okay, so it sounds like you're not disputing that you owe them rent, and you said you want to pay them what you believe that you owe them, correct?
I want to pay what I owe him, yes, ma'am.
Okay, so rent in the amount of, or past due rent, $5,000, what's the prorated amount?
Yeah, it's $40 a day. I calculate 15 days due to the, so that is $600.
Plus $600, so $5,600 plus fees.
Yes, Your Honor, for court costs, I have 110 for the filing fee, $56.13 for service fees, and we will agree to $75 for statutory fees. For a total of $241.13.
Am I gonna have a chance to pay this back and still feed my family, Your Honor? Because if I would have had the money, I would have paid him before it had to come to this,
Oh, let me just make sure I get this correct. I calculated the amount with the past due rent plus the prorated amount plus the fees and costs, and the statutory fee of $75, $5,841.13. Is that what you have?
Yes, Your Honor, the only thing we're missing is the late fees. It's $50 a month for 4 months.
I thought I included that. Wasn't the rent $1,200?
Yes.
Did
Yeah. Then you charge me $12.50 is what your calculations. you said.
Yeah, 1250 times 4 is 5,000.
I'm sorry, Your Honor.
Yeah,
Thank you.
that's what I included that. Okay, sounds good. And then you're concerned about repayment of the debt, correct? You can make a payment plan with him. Okay, or if you can file a motion with the court for installment payment order, okay?
So-
That means you can file on your own, you can get paperwork and request the court order an installment payment.
They're not being real nice to me, so can I just do it that way?
If that's what you feel like you need to do, I don't know that they're unreasonable people and I don't think he thinks you have $6,000 sitting in the bank. I think
It was
that's how we're
just the
here.
way that she talked to me in the hallway.
She's a lawyer. She's here to advocate zealously for her client.
Sure.
But other than that, she's a really nice lady. So I'm sure that you could discuss how to move forward with a repayment, and deal with your finances. That way, if you're not able to, that's what the court's here for. We'll help you. Okay?
So if I don't agree with how much they're trying, I can go up on the court with my.
You can make a motion and then I'll need to see what your finances are looking like, and then we'll make a determination as to what's reasonable, because it's also not reasonable for him to have to wait until he retires to get his money back.
Sure.
So it needs to be reasonable. It's not gonna be $20 a month or anything like that.
Definitely.
Yeah, so
But
we'll,
I gotta make enough to
Right.
feed my family.
right, and you want this over with, I'm sure.
Yes, ma'am.
So that can be done in order to avoid you having to get your wages garnished. That you can request a payment, okay?
Yes, ma'am.
Okay, and we probably would want to wait for you to find out what's going on with the walkthrough and the disposition of your security deposit first, okay?
Sure.
Because that may reduce this amount, or it could be an increase to the amount. I'm not sure what's going on with the property. They gotta get that. Is the stuff still in the property?
Yes, Your Honor, we weren't comfortable touching anything until.
So the stuff is still in the property. Okay? So you didn't want your bed, is that what it was? So you abandoned it?
The twin size, yes.
Oh.
All the stuff that stands in the house is not in the house.
Yeah, well, it costs money to get discard of that stuff. So
Yes, ma'am.
there's a fee for that.
I work for a moving and storage company.
There you go. So you're very much aware.
Yes, ma'am.
Okay, sounds good. Any additional matters today on this record?
May I ask some questions?
You may.
So as of today, as it pertains, you're moved out of the house and
Unless you want me to go get the twin bed out, I definitely can.
I would like for you to remove everything that you moved back, everything that you moved into the house, I would like for you to remove.
Yes,
So
ma'am.
you're gonna give them an opportunity to go and
Can I say
get the stuff
something
out?
too? If you would have told me in text, Mr. Romano,
Well,
I promise I would have did
Well,
that.
it sounds like there was he texted you and asked you if you got all your stuff out. I don't know if you got the text or not, but he has a text where he sent it to you. Did you get all your stuff out? Because I'm in here and there's stuff in here. So if he's willing to let you go in there, that's to your benefit, because then he doesn't have to deal with getting
Sure.
it out.
Absolutely.
You need to get all your stuff. You need to get all the stuff that's there that could be removed, because if you're not, you're gonna get charged for it.
I want to give it back. to
No,
you.
I don't believe that somebody came and threw a party and left bottles on the porch. I don't believe that. You get rid of the trash. Get
Absolutely.
rid of the food out leave a property in broom swept condition. You wouldn't have moved into a property like that. You clean it out when you move out, okay?
Absolutely. Yes, ma'am.
All right, do you have any more questions?
No, I
You all
just,
can make arrangements off the record, because he already gave you the key, right?
no,
Oh, you still have the key?
No, they was on the, I figured when he went in the house, he seen them. They was on the, in the lockbox on the stove.
I took the lockbox and the lockbox was empty. But I took the lockbox. and It's empty.
Have you secured the property?
I locked it when I left and the front door was propped with a 2x4 because it had been busted in.
You'll have to make arrangements with them as to how you can, when you can get in, if you don't have a key to remove your things, because you say you left your key there.
The property's not that, I can get in.
So I guess I would just ask, an additional provision that possession has been turned over to Mr. Romano, that he can change the locks. at
He
this
can't
point.
change the locks.
Okay, thank you. Your Honor.
Because the possession is back to the plaintiff at this point, so
Thank you.
I would still advise you make arrangements for timeframes as to when he can go and get his property. That way you don't end up with any trespassing issues, okay? All right, any additional matters?
Not for plaintiff, Your Honor, thank you.
You're all set, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
No, go ahead and go. I will text you in a little bit. Yep. This exhibit needs to go to the file.
We have one, it's marked in here.
Oh.
Okay.
What did I just sign?
That was,
230?
yeah, that one was the interpreter, yep.
The guy didn't come?
Nope, interpreter's here, he's no show, the guy didn't show up.
Are they gonna get copies of that today? Did you give a forwarding of it?
I can leave you mine.
Yeah, let's go out of here and let's get your contact information.
That was a default.
Oh, okay.
I have the file here.
Oh, thank you.
Okay, Mr. Dua, let's see, who were you
Yes,
meeting
Chair.
with? Who were you
Miss
meeting?
Odom.
Okay, Tanya snorted. She all set in the room?
Yes, Your Honor.
Ms. Tara? Okay, did you and Miss Whitty work anything out, or how are we proceeding?
We have agreed to a conditional dismissal, Your Honor.
Okay, on the record. In the matter of 3031 LLC versus Tanya Snorden and Jamie Martin, file number 23-00854 LT, council appearance.
Good afternoon, Your Honor. Joy Whitty on behalf of plaintiff landlord 3031 LLC.
Felicity Till, PA 3961, appearing on behalf of Tanya Snorden, who is present with me via Zoom.
Okay, very good. Today's the date and the time that's set for a eviction hearing for non-payment of rent. How are we proceeding?
Your Honor, we have agreed to the terms of a conditional dismissal. If you'd like me to read them, I can do so.
Yes, please.
Rent is in arrears in the amount of $5,855. Court costs are $187.31 for a total of $6,042.31. The defendant agrees to pay $840 today, June 21, 2023. She agrees to pay $1,680 by the 30th of each month, and she agrees to pay rent as it becomes due.
Ms. Till?
Yes, that is correct, Your Honor.
Okay, very good. Okay, I've noted that here in the file, and your client understands that partial performance will not satisfy this agreement, correct?
Correct.
Okay, and are you going to get this agreement signed and sent over, or are you giving Ms. Whitty permission to sign? Or is Ms.
Yes.
Whitty giving you permission to sign?
I've given Ms. Whitty my permission to sign in the breakout room, and she's going to be submitting that order to the court, Your Honor.
Okay, sounds good. Your client is not here. She appeared to be in the breakout room, but when I tried to bring her back, she did not return. But once I get the conditional dismissal, I can sign and it'll be all set. Any additional matters for the record?
No, Your Honor.
Nothing for defendant, Your Honor.
Okay, thank you. We're all set on that record.
Oh.
What did I want Miss Show to do an intake with? Did they leave?
It was the Jacob Kawhi.
Oh, I don't see it anymore.
He was in person. He had her.
We had our iPad. Did we get our iPad back?
I'm sure.
I didn't see anybody here for Keith Stillhoff. Did I give? Did we get our iPad back?
Yeah, I got it right there.
Oh, okay. Okay.
Oh, yeah, I was starting. Yeah. Thanks, sir.
Okay, let's see here. I don't see anybody here on behalf of Greg Stillhoff. Who's on the Google Pixel? Unmute, please, sir. You gotta unmute.
Okay, sorry. Can you hear
What's your
me?
name?
Jermaine Pfeiffer.
Okay, Mr. Pfeiffer, do you have a place to sit down?
Yes.
Okay, can you please have a seat? Let me see, Mr. Pfeiffer, actually, is that dismissed?
Yes, Sharon.
No, sir, I don't see it on mine. That's crossed off of mine. Yep, your matter was dismissed, Mr. Pfeiffer.
Okay, thank you.
You're welcome.
I don't know how to get out of it.
Ms. Whitty, you can submit defaults for heat sheet seal off.
Your Honor, if I may, I actually
Yeah.
have a request for the court to adjourn briefly. Apparently, family members are emptying out the apartment this weekend.
Okay.
I can add slot on June 28th at 8:30.
June 28th. Every time
8:30.
at 8:30.
Thank you very much, Your Honor.
No problem. That one was. Did I see Mr. Dower?
That's the one you signed. He's default.
Oh, I did sign
Yeah.
it. Okay, okay, we're moving. Stephanie Pierre is here with Ms. Till. Who's here on behalf of Capital Park?
Thomas Becker for Capital Park, Your Honor.
Okay, sounds good. Ms. Till, did you want to meet with him privately?
Yes, I could. And if we could have Ms. Pierre in the breakout room as well.
Okay, Ms. Till, you're already in room 2, so I'll add them both to room 2.
Perfect.
Could we add Victoria from Capital Park also, Your Honor?
Absolutely. Okay, I thought I see, okay, I see Larissa Odell. Who's on this iPhone?
Yes, Your Honor.
Okay, very good. You don't have an attorney, do you, ma'am?
No, I'm not quite for sure what I'm gonna do at this second.
Your Honor, if I could have a breakout room with Ms. Odell, that would hopefully be beneficial to both parties.
Mr. Drew, I'm gonna put you in room 3.
Thank you, Your Honor.
Is this my iPad? I was trying to figure out if that's the iPad, but it's not because it lit up. Who's on the iPhone?
You guys hear me?
What's your name?
Daniel.
I'm sorry?
Daniel Newcomb.
I think he said, did you say Daniel Newcomb? Did you say Daniel Newcomb? Oh, he's gone. Because his phone's not working. Let's see, this lady won't be brought back. Mr. Newcomb?
Yes, ma'am.
Okay, all right, you're in a place appropriate for court because your signal is not coming in well. You're going in and out.
I was just leaving work. I was at work.
Okay, because your signal's going in and out. Do you have an attorney?
No, I had the little attorney that I talked to that day, but I'm not sure how that works. I'm not even sure how none of this works.
Okay, sounds good. We're waiting for the plaintiff's counsel to appear. You should make, he's gone again. We don't got the luxury side. That's y'all. Y'all over here, y'all got AC over there.
I mean,
It's either gonna be cold or hot. Those are our options, okay?
well, I thought Addie had a heater on for a minute, but I guess
It's right here. That's right.
Oh,
good.
wow.
Mr. Newcomb, we need you to get to a place where you can conduct court. He's gonna have to be reset for in person. I can't do it.
Come on in.
Okay, let's see. We got how many more left to go? Clifford Lofton. Write a note in this one. Stephanie Pierre Odell. You said what?
Clifton Lofton, is that one crossed off or no? Oh, no.
Nope.
So are they gonna prepare the conditional dismissal on that couple earlier?
Ms. Till?
Yeah.
Yeah.
Okay.
This says something about escrow. Yeah, because that's his pink tag. Is it in the dismissal you thought?
For which one? No. I thought it was crossed off.
Is my signal better?
Okay, yep, that is better so far. Let's see. 6, 13. What was this? Oh, the files just marked. Okay. Waiting for Ms. Till to come back on that one. What matter is Mr. McKay here on? Mr. McKay, what matter are you here for?
I'm here for think it's a second hearing on Rocket Mortgage versus Hawk.
We received a conditional dismissal on that.
Right, we have a conditional dismissal as to Amanda Hawk, but we still have to proceed against David Hawk.
Who has the file? Would probably be Sean, put that down, so
Yes.
put it down at civil.
Yeah.
David Hawk did not appear, correct?
I haven't seen the name on top yet.
Is Till following, did she file an appearance for both of them? Just one? Okay.
I said it's only on a meeting.
Oh, you don't need to go with the file, then it's in.
Oh.
David Hawk failed to appear, you can submit default.
Yes, Your Honor. Can I get the email address?
Yes, Judge Simmons Courtroom at lansingmi.gov.
Judge Simmons Courtroom at lansing.gov.
lansingmi.gov.
I'm sorry, lansingmi.gov. Thank you. Have a good day.
Okay. Thank you, same to you. Let's see. We just need the, well, we lost Mr. Newcomb again. I can't. Okay, Ms. Till, are you ready to proceed?
I am ready, Your Honor. Thank you for your patience.
No problem. We're on the record in the matter of Capitol Park versus Stephanie Pierre, file number 23-00885 LT, council appearance. Mr. Becker.
Thomas Becker for Capitol Park.
Felicity Till, PA 3961, appearing on behalf of the defendant Stephanie Pierre, who is also with me via Zoom.
Thank you. Today is the date set for a hearing on a non-payment of rent eviction. The parties did meet privately. Did you come to a resolution on this?
Your Honor, we would like to request an adjournment of 2 weeks in order to allow for the parties to apply for assistance funds.
We'd consent to that adjournment, Your Honor. It's my understanding there was some confusion and some communication issues that we didn't get the request. So.
July 12th at 2:30.
July 12th at 2:30.
So before we go off, Ms. Till, do we have a dispute as to the balance?
No, we do not.
Okay, thank you.
I'm sorry, Your Honor. Could you repeat that hearing date again?
July 12th at 2:30.
Thank you.
Any additional matters for the record?
Nothing on this matter, Your Honor.
Nothing for defendant, Your Honor.
Okay, you're all set, ma'am.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome. I could be wrong. I don't see Piper and it's been locked in here. They're supposed to be at 8:15.
Double check.
Your Honor, I believe that concludes all the matters that I have for you this afternoon. I did have one that was set at 3:30, but I filed a jury demand. So I just wanted to make sure that we're still taking those off the docket and you don't need me to appear at 3:30.
That is correct. That OPP versus Lazier was removed.
All right, perfect. Thank you so much, Your Honor. I'll see you next week.
Thank you.
I believe Ms. Gable's stepping in because she's talking to Mr. Lofton. So she must be standing in for Mr. Piper.
Gotcha. So Mr. Lofton is there.
Yeah, he was here earlier. You see out your tongue too.
Okay, sounds good. And then Mr. Dewar, you're back with.
Your Honor, may I approach off the record?
Okay, Ms.
I
Odo,
think I
can
got
you
it
hear
working.
me?
Yeah, I can hear
Yes,
you
yes,
now.
ma'am.
Okay, sounds good. Mr. Newcomb, I'm still waiting. Oh, there's the attorney. Just a moment. Counsel?
Yes, Judge.
Okay, I do have Mr. Newcomb here. I could put you both in a private meeting room.
Okay, thank you.
Okay, and then, let's see. Let me delete these because. I don't want to open it, put them back in there. Okay. Mr. Newcomb to room 2, and then Ms. Singh.
Thank you.
You're welcome. It's Foley property here for. Okay. On the record in the matter of Foley Property Michigan LLC versus Eric Odo and Larissa Odo, file number 23-00886 LT, council appearance.
Thank you, Your Honor. Sam Dewar here on behalf of the plaintiff.
Okay, and then Mrs. Odo, can I see your face, please? Okay, very good. Today is the date that is set for a hearing. I need to see you throughout the hearing though, ma'am.
Okay.
I'm sorry?
Okay. Sorry.
Okay. Okay. Today was the date that was set for a hearing on a eviction for non-payment of rent. And my understanding is that Mr. Odo is now deceased. Is that correct?
Yes, Your Honor.
Okay, and so are you prepared to proceed with the hearing today, ma'am?
No.
I can't see you. I see a window. Okay. Okay, and it's my understanding is he passed relatively recently. Is that correct?
Yes.
Oh, Okay, and you've not been able to have a meaningful discussion about resolution of this issue with plaintiff's attorney at this time?
No,
Okay, I'm
I
gonna
don't
go
have
ahead.
any money. I don't have any dollar amounts yet because his insurance hasn't kicked in. We just got the death certificate.
Okay. Okay. I am going to reset this matter for in-person hearing. That will give you, Ms. Odo, more time to collect yourself as you appear to be very emotional. And then you can bring any supporting documents or evidence that you need to bring with you to court at that time, okay?
Okay.
That's it. That's July 19th.
July 19th. At what time? 1:30. At 1:30. Did you hear that date, ma'am?
Yes, July 19th by 1:30.
Yep, and that would be in person at the court, okay?
Okay.
Do you have any questions today?
No.
Okay. Any additional matters for the record?
Ms. Odell, my phone number appears on all of the paperwork. Please give me a call between now and then, and we will do our best to resolve this outside of court, okay? To what works for both parties.
Okay.
Okay, you're all set for today, ma'am.
Thank you.
You're welcome. Okay, Ms. Shannon, did you and Mr. Newcomb resolve this matter?
We did, Judge.
Thank you. Okay, we're on the record in the matter of Capital Commons Limited versus Daniel Newcomb, file number 23-00937 LT. Council appearance.
Carrie Zanin, P67390 on behalf of plaintiff, Your Honor.
Okay, and Mr. Newcomb is present via Zoom without counsel. Today's the date set for a hearing on non-payment of rent eviction. How are we proceeding, counsel?
You've agreed to a consent judgment, rent to retain $8,641, court costs of $175, total rent to retain $8,816, possession only, writ issue date of July 3rd of 2023. I explained to Mr. Newcomb his rights under MCR 4.201I, his appeal rights. He also gave me permission to sign this consent judgment on his behalf and submit it to the court for entry.
Okay, Mr. Newcomb, if you could unmute your device. Okay, did you hear the terms stated by counsel?
Yes.
Okay, and so you are willing to enter into consent judgment today, sir?
Yes.
Okay,
What do you
that's
mean by that? Hold
possession.
on 1 second. Oh, yeah, possession. Yeah. I'm sorry.
Consent judgment as to possession only, and the amount to retain the property would be the amount of $8,641 plus $175 court cost for a total of $8,816. That's the numbers you're consenting to, sir?
Yes.
Okay, and that you will pay that or vacate the property no later than July 3rd, 2023. Otherwise, they can request a writ of execution to remove you from the property after that date. You understand that?
Yes, ma'am.
Okay, you understand that you have the right to proceed to a trial in this matter?
Yes, ma'am.
You're willing to waive your trial in order to enter into consent judgment?
Yes, ma'am.
You have the right also to have representation by counsel. You're willing to waive your representation in order to enter consent judgment today?
Yes, ma'am.
Anybody threatening you to get you to waive those rights today?
No, ma'am.
Okay, any promises being made to you in exchange for you waiving those rights?
No, ma'am.
You have 3 business days from today. If once you leave here, you determine that you misunderstood any of the rights that we just discussed, you can return to the court and request to have the judgment set aside. You would have to articulate how it was that you misunderstood your rights. Other than that, are you giving Ms. Stanton permission to sign the judgment on your behalf?
Yes, ma'am.
Okay. Any additional matters for the record, counsel?
No, Judge.
Okay, you're all set. Thank you.
Thank you, Judge. Have a great day.
Same to you.
Well,
we're just waiting for Lofton. Well, that was set at 3:15, so I'm calling the case. They should probably join me.
am I done here or?
You're all set. Thank you.
Oh, thank you. You have a great day.
Same to you.
Yes, Your Honor, we have a conditional dismissal agreed upon. I just have not reduced it to writing yet.
Okay, sounds good. You just put the terms and then you all can work out the writings.
Okay.
Okay. We're on the record in the matter of Sycamore Townhomes versus Clifford Lofton, file number 23-00101 LT. Counsel appearance.
Catherine Gable, P81555 on behalf of plaintiff.
Okay, and Mr. Lofton is here present in person at the court. Today was the date that was set for a hearing for non-payment of rent, and the parties have entered a conditional dismissal. Is that correct, Mr. Lofton?
Yes.
Okay, what are the terms, counsel?
Thank you, Your Honor. So we agree that the defendant owes $4,360 in rent. That's for rent through June 30. He also owes $500 in late fees and $250 in insurance costs for a total of $5,110. And of that $5,110, we have agreed to $600 in credits. We've agreed to 6 months credited late fees and 3 months of credited month-to-month fees at $100 a piece. So the total balance due for rent and other charges is $4,510 plus $155 for court costs. And we are going to give Mr. Clifton until July 5 to pay that balance. If he does not pay the balance, we will receive possession and can file the immediate writ of eviction.
Okay, and that's how, those are the terms that you're agreeing
Yes.
to at this time, okay? Are you willing to waive your hearing in order to do that, sir?
Yes.
Okay. Okay, and are you gonna get that in writing today?
Yes, I'll do it right now.
You're gonna sign it?
Yes.
Do you have any questions for the court?
No.
Okay, we'll wait for you to get it signed. Thank you.
You're
Thank
welcome.
you.
All right, I'm just gonna fill it out. You can sit right here and.
I think there's some money in escrow here too.
So we took that into account when
Okay.
dealing with the rent amount.
So that was applied.
Yes, yep. So. here if you default and you don't
Mr.
pay.
Rosary, which matter are you here for?
Then we can evict you without notice to you.
Are you here for a matter?
Yes, OPV versus Lazaire, Autumn Ridge versus Lazaire.
Okay, Ms. Till filed a jury demand.
Okay,
So we remove the hearing date after that because that's we set for a jury trial.
and.
I think she filed it today.
Okay, does your honor have a new date or not?
Civil will set the jury trial. We don't set it.
Okay, all right, thanks. Thank you, Judge.
No problem. Okay, Mr. Lofton, you do understand that partial performance will not satisfy this. You understand that? What's mean? Oh, okay, thank you. You have any questions?
No.
We'll get you a copy of this.
Want him to complete this form.
Just want him to complete. I gave him his advice and rights. So you want me to fill it out? Or?
He understands those rights. I mean, it's not a consent judgment, but you have an advice of rights there because you understood that you had the right to have a trial in this matter, correct? What's mean?
Yes.
Thank you. You gotta use your words. Okay, and then you also have the right to be represented by counsel, which we advise you of that back on your pretrial date, which you appeared without an attorney, but are you formally waiving your right to be represented by an attorney?
Yes.
Okay, and you don't have any questions about any of your rights, correct?
No, I don't.
Okay, so that form is just to advise you of those rights, okay? That's all I got.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Let's see.
Problem or anything, you call Kathleen, okay?
Thank you.
Always tell people to put it on their fridge or something, so you know you pay
This?
them. Yeah, just so you make sure you pay it on time, you know? What did you like me?
Thank you. Have a
Thank
good
you.
one.
Take
You
care.
too.
We didn't catch you. No shade.